All right, everybody, welcome back. This is part 3 of our deposition training at Pardalis and Nohavicka. So we went over the very basics of what to do at a deposition. And, it doesn't mean that you know that you'll pull off the greatest deposition ever, but at least you won't feel foolish when certain things happen. Before we begin in earnest with the deposition training, I want to talk about a couple of more technicalities that occur at a deposition that might be confusing to somebody who's starting out for the first time. Let's say you have a plaintiff versus multiple defendants, and you're deposing the plaintiff, and the defendant's attorneys are all talking. They have their strategies all, sometimes they share, sometimes they don't. But who goes first in deposing? And it's the same thing as with an inverted caption. Whoever's named first gets to go first. So the first named defendant will have the option to go first. The second named defendant has the option to go second, and etc. And you can change that up. If if you're number 4 and you feel good and you feel like getting some experience in it, you can ask defense counsel 1 and 2, say, hey, would you mind if I started off? And most times, I've never been denied in that situation. And I actually never denied anybody, because you could always catch up and fill in the blanks on whatever questions were left out by the person who wants to go. The next thing that gets raised is, what is the scope of defense counsel's questioning? Defense counsel 1, defense counsel 2. Meaning, let's say you already spoke about all of the pedigree information, or you already spoke about how the accident happened. Is defendant 2 bound by your questions other than ones that have not been asked? And the answer technically is no, you're not. Each individual defendant is allowed to begin the deposition practically de novo. So they can do it all right from the beginning. That only happened once in my career. It was in a case that we handled a long time ago. It was a building collapse, and the case is Maluka, if you guys want to look it up in Clio. It may not even be on there, it's so old. But it was just done for purposes of harassment. The same exact questions were asked. Nothing new was gained. But they did have a right to do it. I don't know what to say about, what do you do if you have like 5 defense counsel and each one wants a full 7 hours of questioning and it's all repetitive. That's something that can be worked out at your PC conference, your preliminary conference, before it is entered into an order, where you can agree that it will not be, that will not be permitted to have duplicative series of questions. This way it puts some kind of, limit to how long the deposition is going to go. Otherwise, if you have 5 defendants, in theory, it could go 5 days, even longer than that. Okay, so that never happened other than that one time, but it could happen, and you are allowed. And just remember, if defense counsel number 1 goes first and they do a terrible job, and you want to do the whole thing up to get your rhythm and to get a nice dialogue going with your witness, you're able to do that. So you're allowed to do that. What happens when you have your multiple defendants and a leading question is asked or something to form, and defense counsel number 1 says objection to form, and 2 through 5 decide to do nothing, thinking that that objection covers them? Well, the fact is that they are not covered. And if you did not, if defendants 2, 3, 4, 5 did not object to that question, it can be used against them at trial, and that objection will be deemed waived. So what do? Sometimes this is what happens: objection, 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 objection. That sometimes that happens. And that's proper, and you'll see that in the transcript. The best way to do it, just so it's not repetitive, it's just we hear objection to form, you say join, 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 and that's it. I know it's not a big deal, but every second counts, and it's so horrible hearing objection multiple times. But make sure if you hear one defendant object to it and you feel the objection can hurt you, then you have to make your objection. You have to join in the objection as well. So that's a technicality that's important to do. Don't let it sit. Don't think you're covered by it, because you're probably not going to be covered by it unless the question is just, ridiculous and the judge doesn't allow it. But usually they will. If there's been no objection, it's going to be deemed waived. All right. So those are the technicalities, and I'm sorry that that's not the most exciting stuff in the world, but and that's not going to help our non-attorneys who are here, also who are learning, hopefully joining us so that they can ask better questions for purposes of intakes and client preparation. That's what the purpose of this is also, not just conducting great depositions. Okay, so let's talk about the deposition in earnest. So here we are. We had our two training sessions so far, feeling a little better, but not quite confident to go into a brand new kind of case. All right. So, and I know that some of you have had legal training that is different from this, and that may be at odds with the way we do it. But I just want you to keep in mind that I'm not going to tell you exactly what questions to ask, and that's going to be applicable globally to all your cases. I don't think that that's possible. I mean, they do have excellent tools, such as the pattern deposition questions. You really have to get that in the library or order it online. And they have pattern questions that you can ask, and they're sample questions that you ask at certain types of depositions. I promise you that's not going to be enough, but it would help you getting used to what kind of questions that you want to ask, and even how to ask the questions. So, and just one more technical thing before we get into it. Try to remember that even though you're allowed to ask leading questions, remember that the best questions for you are the questions that are who, what, when, where, why. Open-ended questions as opposed to the leading questions. If you're using leading questions because you feel you need it or you have a difficult witness, try to phrase the question so that their answer is yes. The light was red at the intersection, right? Yes. Because yes answers just have better value at trial when the jury hears it. They also psychologically have better value for the judge or for the law secretary or law clerk that is working on. So try to and I'm going to remind you about this again, but try to get those affirmative answers rather than negative answers. Jurors don't like it when they think that lawyers are trying to control somebody's testimony. And that's exactly what cross-examination is. You are, in fact, controlling the situation, but you don't want to put it into their face. You just want to let them know that this is the way you're asking the questions because you already know the answers. And look, they're agreeing with you. Okay, so psychologically, that's very effective. It's very important to do. Having the negative answer, like, no, I didn't sign the contract, that can be helpful too at times, But I'm telling you, always aim for the affirmative answer, and you'll be much better off. I think you'll have a more valuable answer. All right, so here we go. New case you're assigned to. It's a personal injury case, and your firm is representing the plaintiff in this case. And your firm mostly does defense work, but you know what? Sometimes you have to do what you're assigned, and that's the end of it. And in this particular case, we have an elderly woman, and she was involved in an accident while she was visiting a physical therapist. This particular accident took place in an office, but it's a slip and fall. And the way we're going to go into this is going to be exactly how you would go into most personal injury, slip and fall kinds of cases. And this is going to be valuable for you whether you're doing an intake to find out, about whether the plaintiff has a claim, or to find out how the defendant is going to claim. You're going to need an understanding of how to ask the questions to get the information that you need. And I can't remember what the next point was, but just assume that it was important, and that's how it is. So then we are going to talk about from the plaintiff's perspective only today. Okay, so here you are. You don't have much to go on. We don't even have any transcripts available for you to look at right now. Okay, so you're kind of on your own, and you're assigned to do the deposition tomorrow. And you've had some training. You've had 2 hours of deposition training. And now you're going to take on your first deposition, and you're going to be the person in control of the deposition because it's all yours. What do you do? All right. So the first thing is, and I tell this to our administrative staff, that the more chaotic things become, the more calm you have to become yourself. If you panic, your mind is going to race, and you're not going to be able to collect your thoughts. And what you're going to need right now is pilot cool. All right, because you're going to be nervous. You're not going to be sure. You're not going to be confident. And the reason is because you're not prepared. But you know what? You have time to prepare. And that's exactly what you're going to do. And that's exactly what I'm going to explain to you how to do it right now. All right, congratulations. You're going to do your deposition. Everything's set up. You have a great admin team, and they have everything set up. They ordered the court reporter, and you have the location set, and so you start going through the file. All right, for a personal injury action, like most actions, you go to the complaint first. In slip and fall cases, you're not going to find very much information other than the names of the parties there, if you're lucky, and the index number, and you might find out where the accident took place and the date. It's not going to be enough. You have to go to a document that's called, and this is in state courts, we're going to go to the bill of particulars. And the bill of particulars is not a discovery document. It's like a complaint, except it's amplified. It's just, if you take that complaint and the bare bones allegations that are in there, it's just amplified so that it gives you more specific information. All right, so you know who the parties are. You have your bill of particulars in hand, and you're going through it, and you find out that the accident took place on February 25th in 2015. It took place at a place called Recovery Physical Therapy in New York City. And you know what, it even gives you the location of where in the office it happened. And it tells you that it's in the second curtain exam room. It's by the second curtained exam room, somewhere in there, by a table or something. And so now you know that the person is injured. And in the bill of particulars, it's going to explain exactly what the injuries were and what treatment was needed. You're not going to really need that information. So you can stay away from the meds at this point, because the person that you're going to be questioning has no injuries. So it's not going to matter. But what you have to do now is not the most fun of the process until you've completed it. And that is developing a theory of the case, the theory of the defense. The theory, in this case, the theory of the prosecution of this case. What did the defendant do? Why are you suing this person? I mean, look, you could just look at it and say, hey, somebody just fell and while they were getting dressed in an exam room and they got hurt, and that's it. Things happen. Okay, that's not a good theory. You have to develop it more. And so your theory in this case is probably something along the lines of, we have an elderly woman who was left alone, and the only support she had to get change was this rickety chair with wheels. No one went in there to help her. It was a slippery floor, and she fell down and she hit her head, or she hit part of her body, and she was required to go to the hospital. Okay, so that's the theory, the plaintiff theory of the case. So now you're going in thinking like, okay, how do I develop, remember the quadrants? All right, we know in an auto accident case, our quadrants are set up first with the pedigree information, the background, and then we get into the how the accident happened. Then we get into the medical treatment, and then finally we get into the aftermath of the accident. Okay, that's your quadrant. You're going to fill in each of the quadrants. That's a car accident. That's easy. Okay, your crosshairs are set, and you're going to populate all of those questions that you have, and all of those concerns that you have about the case in each quadrant, and take care of it. So how do we develop the quadrant here? Well, the first is going to be the same as the motor vehicle accident. We're going to talk about pedigree. All right. The second part of the second quadrant is going to be the history of the defendant company. All right. In this case, it's a professional corporation. So we're going to find out a lot of information about how it was set up, and we're going to talk about the office and the setup there. The third quadrant is going to be the event itself, the accident. And then the fourth quadrant is going to be very similar to the to the plaintiff case in a motor vehicle accident. We're going to talk about the aftermath of the of what the company did as a result of this accident, what actions were taken. All right, so let's just break it down. Okay, we're going to start with the pedigree. All right, and in this particular case, we have a Russell Pardalis, and I'm not exactly sure who he is, but he's the person who they're producing. He might be the physical therapist, he might be the owner, but I'm assuming that he is a manager of some sorts of the office because he was named personally in this case. All right, so we have the PC and then we have an individual named here. So that's delicate because it's very hard to pierce that corporate veil that we have in New York. So that's going to shape what our quadrant's going to look like, and it's going to shape the kind of questions that we're going to ask. So in the pedigree, we're going to talk about let's say if this is the physical therapist, okay? So, and I don't know if it is Israel, sorry, but so we're going to talk about his education. We're going to talk about his employment history, okay? And I usually start with the defendant. I will go from after high school. If there is any. If there's nothing after high school, then I'll talk about the high school. We're going to, of course, we're never going to forget 4513 of the CPLR, which is the criminal history. We're going to talk about whether he's filed for bankruptcy, whether he served in the military, whether Dr. Pardalis or Mr. Pardalis served in the military. What awards, if any, he has received, civil or military awards. And here's a really important one. We're going to ask, a clunky question to ask, and I mean clunky by awkward, as far as building your rapport and getting into a groove in the deposition, is that you don't want to ask, have you ever been sued before, right off the bat. All right, you're going to get objections, and they're probably going to be, if it goes to emotion, it's probably going to be sustained, a general question like that. But there are other ways you can get that information without asking that question, without sounding obnoxious or putting the defendant on the defensive. You can just ask, have they ever been deposed before? And that one question, if the answer is yes, is going to bracket into other information. And because if they have, then you got to get that deposition transcript, because it's going to be valuable. There's going to be something in there to help you out. It's going to give your assistant some work to do in comparing the deposition that you conduct today with the deposition that was conducted 5 years ago. You may find inconsistencies. There's always something in there if the transcript is large enough. You're going to ask them whether they ever gave testimony anywhere before, where they swore under oath, where they gave an oath like the one that was just given to you moments ago. That is going to possibly lead you to some very valuable information, and you're not being obnoxious by saying, you ever, talking about their prior suits or their prior involvement, because it doesn't matter whether they were sued. You don't need that information. You just want to know if they gave testimony. You'll find out where they were on the opposing sides of the V when you get the transcript, and that'll lead you to other information that may be helpful to you, possibly. You're going to ask whether they signed any statements under oath for any purpose. Think about that. There are sometimes, like for a car lease, you have to sign under oath. You have to swear that the contents are true. If his answer is no, maybe that's helpful, maybe it's not, but it's something that should be asked. But it could have been something, it could have been a declaration or an affidavit that was submitted in another action. That would lead you to other information that you could get later on when you come back and to the office and you have, somebody doing the notice for discovery and inspection. These are things that, you're going to call for production of these things, or even call for production of the documents at the deposition itself. Another technicality. Let's say that they say they don't remember, but they may have, and you say, okay, is there anything that would refresh your recollection as to whether you have something? Yeah, I think I have a document at home that would refresh my memory. So what you say is, all right, I'm just going to ask the court reporter to leave a couple of blanks in the transcript here for you. And when you've been given an opportunity to read the transcript, when you come to this portion, if you have refreshed your memory at that point, I ask that you fill that in and provide it to your attorney, and your attorney will give it to me. Can you agree to do that? And usually they'll say yes. You know, a lot of times the deposition transcripts come back and, you know, no one followed up on it, but sometimes they are followed up on, and sometimes you do get the information, some very, very valuable information in there. So that's another technicality that you should remember, leaving blanks in the transcript. The court reporters don't mind. They get paid by the page, you know, so they'll be happy to do that, and they don't mind, you know, not having to work at all, like leaving a couple of lines in there. So don't feel bad about doing that, even if you have to do it multiple times. And any kind of document that you want, or any information that you need. You know, for example, you know, you're saying, have you ever been deposed before? And they say yes, and you say, and who's your attorney at that time? And they say, you know something, I really don't remember. And you say, do you have documents at home that will refresh your recollection? And they say, yeah. And you say, okay, I'm just going to ask the court reporter to leave blanks over here, and you just provide that to us, okay? I know I'm being repetitive, but it's a really important little device to use, okay? And you're going to hear it often. And if the opposing counsel says it to your witness, you don't have to agree right away. And the parlance is, we'll take that under advisement. All right, that's all you have to say. We'll take it under advisement. Say you got something cool to say that I gave to you in case you didn't know that. They'll be taken under advisement, counsel, and then they'll proceed with their questioning. So the next couple of questions, I don't. If I have established a good rapport and it seems that the witness is being friendly, I don't ask this question until the end of my deposition. And the question is, you know, when it involves a doctor or professionals, whether they have been the subject of disciplinary actions. Okay, it's a nasty little question, I know that, but sometimes that can lead you to very, very valuable information. I know what we're talking about a defendant here, but you might find something that goes to credibility. And if it goes to credibility, then you've got a chance to get that in at trial, okay? And the more little things that you have, the better the leverage is, and the more willing the opposing party becomes to settle the case, which is, you know, another goal. I mean, winning the case is your ultimate goal, but settling the case is, and that's the best, right? One less thing that you have to do, and one less trial. You know, even if you like, you know, if you enjoy doing trial work, which we do at this firm, having one less trial to do is not such a horrible thing, especially now. So that's going to be your pedigree quadrant, okay? And I'm going to break that down into even further questions and more molecular questions, but not today, okay? Because we're already running out of time, and it's already you know, 3:30, so we have to move along because we're only in the first quadrant. All right, and I know you're anxious, if you haven't done a deposition before, to have those questions there, to have that baby blanket, all the questions written out. But as Carla Gonzalez told us last time, and you know, her professor taught her that you should not have the questions numbered and in front of you, you know, and reading off that. I agree with that completely. You shouldn't do that. But you know, for the first couple of times, it's not a bad idea. In addition to creating your quadrants with the, you know, with the 4 headings, it wouldn't be a bad idea to do a practice run to go through the questions. It really wouldn't. You'll see though that your plan goes right out the window once the witness takes you know, a left turn, and then it's like, okay. So if you're not bound to your baby blanket, that's a good thing. But I think going through the process of writing the questions out familiarizes you with, you know, where you're going, you know, and will keep you in line for the development of your theory and what you're going to do to prove it. And you know, your goal throughout the deposition, through the deposition of poor Russell Hartofilis, is that you're trying to lock him down in what he's going to testify to at trial. You're trying to find out information about him that could be used to impeach him later at the trial, or you're finding out that he doesn't have any of these things, in which case you will have to be frank with your client and say, look, this person's squeaky clean. I'm going to have a really tough time. You know, he's served in the military. He worked during COVID, and you know, he volunteered time. He's going to be a very sympathetic witness. So we really have to focus on trying to settle the case rather than going all out to trial. And that's, you know, and this way you could explain to the client by using the deposition transcript itself. Okay, I got off track here. Okay, so now number 2, quadrant 2 is we're going to go into the history of recovery, physical therapy, PC. Okay, so why are we talking about the history? The history is important because you want to know all the players. You want to make sure you have all the players, all the decision makers. And I know we're talking about a defective stool or a slippery floor or something, but it becomes more clear later on why you need all of this information as to, for example, like who held back the funds, who voted not to get the better and safer equipment in the room, who voted not to have the bars put up so that they could hold themselves up while they were changing, who was the one who voted to not assign somebody to monitor an elderly person who is changing, especially if they're unstable. And you know, I don't know why the person was being treated for physical therapy, but it's probably because something wasn't exactly right and was getting fixed. And now you leave them alone in there to get dressed and balance themselves on this slippery floor with this rickety chair. I mean, you know, you have to start thinking like that and trying to develop it, because that's the best case scenario. You know, that's what you want to be. If that's what your record indicates, then you're golden. You know, then you don't have to feel so much pressure. But that's why you're getting the history of the PCs. Who are the decision makers? Also, since you named the individuals, you want to find out if they followed the corporate form. Because if they did not follow the corporate form, then you can pierce that corporate veil and go after them individually. So now you have another pocket to go after. And isn't that our goal, to maximize our clients' wealth? The answer is yes. And that's what you have to do. It's our, I mean, you know, it's a personal injury case. It's your moral imperative to do that. So, you know, you're going to find out like who formed it. You're going to find out, you know, where is the corporate kit kept, because that will tell you everything. And only a few of our clients who let me do it here in Astoria, only they have books that actually have writing in the kits that explains, you know, on the ledgers, like what's happening, who the shares went to, when meetings were held, the minutes and things like that. You know, how many times we have represented people that, you know, didn't have these things. They had the protection of a limited liability entity, but they didn't follow the corporate forms, and they really risked losing that protection. And that's what happens. But we know that this is what we do. This firm does transactional work, so we understand the importance of that. So we use that knowledge to go after the other side. And that's what we're going to do to recovery physical therapy. We're going to find out all about it. Location of the corporate kit, where is it? And then you're going to ask for production of that in your notice for D&I. Then you're going to talk about the space. You're going to talk about who, you know, the space where the accident happened. Who decided, you know, that this was the proper space? What was done? What, you know, were there any kind of inspections prior to opening? What modifications were made? What renovations, if any? Who designed the rooms? You know, and so I don't forget, you know, when you're talking, we're going to get there to the event, which is in quadrant 3, but I don't want to forget, I feel like I am. So when you're talking on the record about the specific room, the first thing you have to establish is what you mean by left and right. Because depending on where you're standing and how you're standing, left and right doesn't mean anything. It can mean one thing in question 25 and can mean a completely different one in question 150. So you have to keep it, and this is part of the discipline. And you have to explain to the witness that I want to talk to you now about, and you use headings, I want to talk to you now about the office where the accident took place. Okay, Mr. Harfilas, and you say yes. And now when you're at the doorway of that office and you're facing in, what is to the left of you as you're standing there? What do you see? What equipment is there? And as you look to the right, what equipment is there, if anything? What is there? Are there cabinets? Are there, you're developing that so that you're always left and right always means the same thing. So you can do it the opposite way, facing out. I always do it facing in. And that's the same thing with the car accident case. Left and right, I turn left, that doesn't mean anything. You have to say, in a car accident case, you say passenger side, front passenger side, driver side, front passenger side. Those you don't say left and right. It's going to mean nothing. You're going to have a transcript with beautiful questions. The questions weren't objected to, or you want an objection, but it's not going to mean anything, left and right. So you have to establish directions first. What are your directions? And I promise you, with that one tip, and I'm going to repeat it again, hopefully if I remember, but we'll see. We'll have to read this back and see if I forgot it. You'll have a really, really clear transcript when you read it, and you'll be able to recreate it, and you'll be able to use your photos, and you could actually put the directions that you used in the deposition on your photos itself, and it'll be uniform throughout the litigation. You have to see some of the messes where that left-right thing was confusing. The photographer used different left-rights. The witness who was injured had different left-rights, and it's just ridiculous. And you can avoid that simply by understanding, and everybody having an understanding of what you mean by left and right when you're in this examination room. All right, you're going to talk about how long they had the space. You're going to talk about whether it's leased or owned. You're going to get copies of the lease. You're going to get copies of the deeds if there's ownership involved here. You're going to ask about the acquisition of the furniture and the equipment. Who bought the furniture? Where was it purchased? What was done? Was it purchased new? Do you have the receipts for those? They might have just picked up something off of 35th Street and just dumped it in their office, and there you go. There we have our examination seat that was never maintained and broken from when we first put it in there. I know it's hyperbolic, but it could happen. It could happen. I'm sure if you went into a couple of offices down here, that you would actually get that same story. And then you're going to talk about the staff at the time of the accident. That's when it's really important in this type of case. You're not going to talk about all their staff, before the accident, maybe after the accident, but at the time of the accident, you're going to be asking them about who was working there, everybody who was working there on that day, at that time, who was employed at that time, and who's not employed now. Because you might find out that, somebody said, hey, I told you that lady was going to fall, and they said, really? You're fired. And that could happen, and that has happened. So that's you're already in quadrant 2, and you have all this great information, all this stuff, and your transcripts again, and without having written out the questions, you already have a whole bunch of questions formulated in your head and subjects to get into. And as we mentioned each of the things, like just for example, like the corporate kit location, that's going to bracket off into a whole bunch of other questions, like where it's kept, and how long has it been kept there, and when was the last time you saw it, and what's the last known address or contact information for the person that does have this. And if you look at the initial part of the handout that I gave you of my individual critiques, which I'm going to clean up, I promise you, but if you look at those critiques, I pointed out, it's like, okay, you asked about this, but you never followed up with that. Why not? And that's why you have a 40-page deposition, that's really, with left, right in it. So, and so I don't want that to happen to you. And I wasn't making fun of them too much. All right. And they never did it again, so once you get out of these things, talking about this now, you won't do it yourself, and you won't have to go back to your managing partner and say, here's my depo transcript. That's not going to happen to you guys. All right. As of since you started this. So now we move on to quadrant 3, which is the accident itself, the event itself. And this is really important. I'm all the quadrants are important. I know, but I think I'm saying it's really important because I'm talking about it now. So you're going to confirm the information that's in the BP, in the bill of particulars. Remember, that's your attorney did that. Somebody from your office prepared that bill of particulars. All right. And the information that they got was from somebody who was injured and somebody who was elderly, somebody who may have been on medication. You don't know. You have to confirm it. All right. That's one of the purposes of the deposition too. You're confirming facts. So don't not ask the question, right? So ask the question, even though it's in the bill of particulars. Just because it's there doesn't mean it's correct. Confirm. All right. Confirm with their testimony. Or you know something? Let them give the wrong time, a wrong day, the wrong year, whatever. That will go to their credibility as to their memory and their ability to remember the facts. It's you have to ask these questions even though you have the information in front of you and you know it. So you are going to ask the date, time, and location. You're going to ask about what records were kept of the incident, what records they have. And that's going to bracket out into who made the records, who keeps the records, where are they now? The people who keep them. What's their last known names and address? Last known addresses and telephone numbers, whatever, or email, whatever information that you can get from them. Oh, you don't remember? Okay, well, I'm going to have the court reporter leave a few blanks in here so that you can fill out this information at a later time if you have something that will refresh your recollection. I'm going to keep saying that because I want you guys to get that drilled into your head so you remember to do it. Don't forget, it's important. How was the information conveyed to you? Did you see the accident? What did you see? How did you find out about the accident? And when you did find out about the accident, what did you do? And that's going to go into areas like, did you call your insurance company? Who was your insurance company? What information did you give them? How did you give them the information? Do you have copies of that as part of your business records? I called for production of the incident report that was filed with the insurance company. I'll follow up in writing, and if you can just give it to me as soon as you can to counsel, I appreciate that. I'll take that under advisement. Whatever. All right, so then you give them your notice of DNI. Fine. All right. What is it going to do? Delay it for a week or two? You're going to find out all the information about all insurance companies that have been contacted. There could be information in there that can help you, even though sometimes insurance information, such as reports, are given what's called a qualified privilege. And you don't always have to turn that over. But if you can't get information, if you're seeking some kind of information that you can't get anywhere else, and you can prove that to the court, the judge will order production of those documents. So ask about them so that you know if they exist, that you have someplace to go in case you can't get it elsewhere. We're dealing with a physical therapist. Did you do anything with respect to the treatment of Ms. Redder? The answer may be yes. What did you do? You find out. And did you receive training in that? Have you done that before? You know, it just bracks out, gives you more information, and it's all going to depend on the relationship that you have built with them. Were statements taken of the employees? Anybody who saw, anyone who was there who saw? Who was the last person who saw Ms. Redder before she went into the room? Who was the last person that saw her go into the room when she changed and fell down? And who was the first person that saw her? What did they do? Who did they tell? And who was that person? What's their last known contact information? What did they tell you? How did they tell you? Was it in an email? You really, once you get a feel for this, you have to limit yourself because it just goes on and on and on. So, you know, to somebody who's been doing this for a long time, the 30-page transcript is a mystery. And it's just a result of not taking the time to think about your case, you know, to take the time to, and it doesn't take long, I'm telling you, to develop a theory and to build your quadrant and how you're going to approach and how you're going to point that quadrant, those crosshairs, at your witness. What other things are you going to ask? And we're still in quadrant 3, okay? You're going to ask about the weather that day. Why? It could have been snowing, could have been icy. It was February. You know, there could have been water in there. There could have been tracking. who's the one responsible for mopping these things up? Who takes care of the floor? You want to talk about the condition of the office at the time. You want to talk about whether inspections of the office are done. Is a walk-around inspection done at the beginning of the day, at the end of the day? Are several walk-around inspections done throughout the day to make sure that there's no equipment broken or things laying down that may cause that may be traps for people, or especially if there are children that go there. And you can even ask about that, whether children are sometimes in there, not as patients, but are children in there? Because if they are, and you know that there are children there, you're held at a higher level of responsibility. You're obligated to make sure that children are safe and that there are no attractive nuisances there. And a jury is going to hear that. And if you're the plaintiff, you're going to be telling you that this is a case about safety rules, and these safety rules were broken, and that's why my client is injured. And you're going to develop all that because there probably were rules, and the rules probably weren't followed, and that's how this woman was injured. And you can find out who these individuals are who performed the inspection, and how they were taught to give inspection, what was required, how did they report that the inspection was done. Has there ever been a time when an inspection resulted in a change or in a repair, or and you want to get this, and you want to get their records and everything. So that's the important thing too, that you want to get the records. I mean, you should come out of here unless you already have them, with a request for a whole pile of documents on these things. You want to ask about pictures, whether pictures were taken before the accident, at the time of the accident, or since the accident. You want to talk about the lighting at the time of the accident, and whether it has changed or whether it was different from how it was before and how it is now. That's three separate questions right there, just on the lighting, which may not, be anything at all. But if somebody says, something light was blinking that day, and, it was, things were out, we're having an electricity problem, whatever. Well, something that's the condition that they may be responsible for. And also the landlord could possibly be brought in later because they were negligent in keeping keeping up the office. That's a stretch, but it's possible, especially if they're the owner. So you don't know. So you have in quadrant 3, you have all these important things. And see, I forgot what it was that I was going to impress upon you that I mentioned in 2 that I was going to bring to 3, and it's just gone from me. It doesn't matter. I said it and it's done. I don't have to say it twice. That would be repetitive. Objection sustained. So now let's talk about the 4th quadrant, which is after the accident. This happens from when the ambulance is called. You can find out who called the accident, what time, how they contacted them, what was said. You're going to, from the time of the accident, from the time the ambulance picked up the plaintiff and brought them to the hospital, other than looking around at each other, with these blank stares, what happened next? What did you do? Did you inspect the stool? Where is the stool, by the way? Do you have photographs of the stool? They better have that stool. If they do not have that stool, they threw it in the garbage. You have a beautiful claim for spoliation. And for the non-attorneys, spoliation is when you take evidence and you destroy it, or you get rid of it and make it unavailable. And even if it's negligent, the worst you're going to get is an adverse ruling, meaning that the judge is going to tell the jury that there was a stool there. It's the plaintiff's theory that the stool was defective. The defendant threw it out, so they can't prove it to you. So you may assume that it was defective. How beautiful is that? You didn't have to prove anything. You just had to say, like, we asked for it and they didn't give it to us, So that's really a valuable thing. So a valuable, you want to know where the stool is, and you want to find out, how that particular, and we already talked about that with the history of the PC and how that, what is the history of that particular stool. A stool is going to be a very important prop in Israel's trial when he does this. They're going to talk about, since the accident, the change in the furniture or the change in any equipment. changes in the structural changes, new floor, carpets put in. We talk about in law school, we talk about subsequent remedial measures, meaning, okay, something was broken, so we fixed it, all right? And usually you can't introduce that at trial, because they're afraid that the jury will say, oh, well, if they fixed it, then it must have been broken and it must have been the cause of the accident, and that's why they fixed it. So usually that subsequent remedial, subsequent repair is not going to be allowed, or even a subsequent change is not going to be allowed. Unless, and there's always an unless in the law, as you guys know, unless it's being used for another purpose, unless it's being used to show that they had control of the chair, or, they may come up with some cockamamie theory that, this was a chair supply company that they would bring us new chairs every month. Something ridiculous like that. I've never heard that actually, but I don't think, but it's something like that can come up. This stems that argument, so it's not going to happen. You're going to talk about, and this is going to be a before and after. I know we talked about after the accident, but whether special accommodations were made when treating elderly patients, and what they were, and who developed these practices, and whether that practice was performed on the day, and if not, are they performed now? Who does these things? Who knows about these things? Where are their records that these things that this procedure actually existed? All right, so these are important things that may or may not be admissible at the time you're asking, but that could change. You're going to know by the time of trial, but at least you have the choice. By asking about it, at least you have the option. If you don't ask about it, then your option's gone. And you have to say, oh, well, it wouldn't have been allowed in anyway, and live with that. Good luck. That's not a good thing. And then you want to ask, and this is where sometimes I ask about about whether you've been sued before, which I'm going to get objections to. But now I'm at the end of the deposition, and now I'm going to be okay with asking the questions that I should have asked earlier, just in case, so I didn't forget. But I remembered, I wrote it down, and I was going through because I took notes during the deposition of things that I wanted to ask or I want to catch up later on. And and you're allowed to do this. It's your deposition. Before you close the deposition, you could say to the court reporter, we're just going to go off the record. I just want to review my notes for a couple of minutes, 5-10 minutes. Let's take a 5-10 minute break. Don't be afraid to do that. It's your deposition, and you're entitled to that time, unless it's a 7-hour time limit, which we have in federal and in commercial part in New York. You only have 7 hours, and you've already used up 6 hours and 58 minutes. So and that's the only situation where I would not take my time to go over my notes and see what it was that I wanted to ask that I forgot to, or that I wanted answers to that I never got throughout the deposition. And I'm going to, make special notes there, and I'm going to go back on the record, and I'm going to ask, have you ever been sued before this? Have you been sued from the time that this accident took place, from the time this accident took place up until today, other than this lawsuit? You might get objections. Don't argue with your opposing counsel. Just say, you don't need that information right now. Just say, mark it for a ruling. All right? That's all you have to do. Tell the court reporter, mark it for a ruling, I'll move on. That's all you have to do, okay? Don't explain why you need it. Don't explain the relevance of it. That's not for opposing counsel to ask, and that's not for you to entertain. So don't do it. You're just going to end up staying at a deposition much, much longer. And then the final jab that you want to give to this person you had an excellent rapport with during the whole deposition is whether there were any other accidents before this accident took place that we're discussing today, and whether there were any accidents from the time that this accident took place up until today at that place. Take the objection, take the hit, mark it for a ruling. Important words to remember. Mark it for a ruling. And I know that some of you, not all, are Cup of Joe fans, so you read this latest installment and you saw some pretty disgusting behavior. And you're not, if somebody's attacking you that way, If you can get them just to repeat it or have the court reporter repeat back what they said, you're not going to object, but you say to the court reporter, mark that for the court's attention. Got that? Mark that for the court's attention. And they'll pipe down. All right? And you know something? That brings us to the end of today's presentation. So now let's take some questions. Come on, guys. I know you have reactions out there.
I just have
Greg.
Okay.
Oh, Gianna, go ahead.
Just really quickly, when you're going to a deposition, do you sometimes have more than one theory of defense? Because I'm wondering if you ask questions that aren't going your way, do you switch?
Absolutely. I've changed theories in the middle of trial. Ask Taso. He'll tell you.
Almost every time.
Yeah. Yeah, you're absolutely. You're not, just because you have developed a theory, you know, at some point, and even before a deposition, doesn't mean you're bound to it. You might all of a sudden discover things that are incredible and give you an even better theory. You know, the process of developing a theory, the process of creating your quadrants, that's just to give you confidence to go in there because you have a plan. You're not just going in and hoping for the best. You know, that's the purpose of it. But the answer is absolutely. We're fluid, man. Absolutely. Good question. Come on, Greg, man.
What are the ramifications of a witness that fails to fill in a space in the transcript?
Well, let's say it's something that you really needed and you're cross-examining them. And all of a sudden they mention this particular document that was produced for the first time, like months after. You could say during their cross-examination, you know, you produce, you know, exhibit B in evidence right now, today. And I asked you whether you had this information. We were at a deposition in October of 2020, you remember? And you were there with your attorney and you swore to tell the truth and you were truthful during that examination. And I explained to you that if you did not have this information, that when you got it, that you would produce it or you would give us the information in a blank space. And I'm just referring you to page 25, line 13. You see that? And you said that you would give it to me, didn't you? Because you knew it would be important, didn't you? Because this case was going to go to trial. And you know that I'm representing somebody who has been injured, who needed that document. And you made the affirmative decision not to give it to me until today, when I had very little to do with it right now. Something like that, you know? But that's how I treat the blank spaces.
Thank you.
So they could be pretty nasty if it's done, you know, and all of a sudden, you know, documents appear out of nowhere. You know, you won't get away with it so much in federal court, you know, because your joint pretrial conference, everything's set up and set down in the pretrial order. So you're kind of stuck with your evidence there. But you're not going to get impeachment evidence at the GIPTO. You're not going to get that there. They don't have to produce impeachment evidence, even if they're documents. But you can object, ask for a sidebar, and explain to the judge what happened. That might be very helpful to you. And under Rule 37, they may get sanctioned for that. That's Federal Rule Civil Procedure 37. So,
How about disciplinary investigations that don't lead to censure, reprimand, or disbarment?
yeah, that's not going to be admissible. But you know what? You'll have that information there, so that might lead you to something else, or maybe hit a sore spot if you need to soften them up a little bit if they become nasty. So, but that's not coming in.
Thanks.
You're welcome.
I have a good story about that, but anyway, it's for another time.
I'd love to hear it. Love to hear it. Actually, we have an article in the Law Journal about Mazzella versus Beals about using disciplinary consent award against a doctor, using that at trial. So,
I'll be brief with it. I was defending on a malpractice step for a guy. I'll call him Shelley. He was an MD and a JD, who did have a censure. Other side knew about it, it's public record. However, within the censure, which was for conflict of interest, the appellate division noted that the censure was in place due to prior conduct. And the prior conduct at question was that Shelley, who is an MD and a JD, was trying a case, a med mal case, and during a break, in order to show the court reporter how disgusting it is to smoke cigarettes, he kissed him full on the mouth. So I spent
Oh my God.
the entire deposition on pins and needles, hoping they didn't recognize that there was a prior investigation. That did not.
Oh my God.
Censure or reprimand. So anyway, it's just something to bear in mind that just because there's nothing on the record doesn't mean there's nothing there.
Absolutely. Excellent point. I love that. I love that. Thank you, Greg. Anybody else? No reactions? We will conclude. Installment number 3 of deposition training at Pardalis and Nohavicka, and number 4 will be next week. I'll see you guys then, okay?